Hello friends. In today's video I will further explain how to bring your dependents to the UK even if you are on the care visa as a care assistant or senior carer using the latest case manager guidance, released by the Home Office on April 4, 2024. I have heard some cases of people making mistakes that potentially mean that their dependents cannot continue to stay legally in the UK. This could have been averted should they have been privileged to the information shared in this video.
My name is Peter and welcome to Visa Pathfinders.
I will like you to subscribe to this channel if you haven't done so. Let's get started. First of all, if you are thinking of moving to the UK and concerned about being able to enter with your dependents or they joining you in a later date, the latest from the UK government is that all immigrants on a skilled worker visa are permitted to be joined by their spouses and dependent children apart from those who are sponsored for a job in the occupation code 6135 care workers and home carers or 6136 senior care workers. Previously 6145 care workers and home carers or 6146 senior care workers under the SOC 2010 classificat. IN. Therefore, the first way to move to or stay in the UK with your dependents is to get a skilled work visa for a job other than a carer. Meaning that if you enter as a nurse, carpenter, doctor, roof tiler, and in fact, recently as a babysitter, your dependents will be granted a visa to be with you. Secondly, even for the so-called care assistants, home carers, and senior carers, there are exemptions to those who are allowed to either continue to support their dependents on their visa or add them in ULI to their visa. To come are these exemptions with relevant examples. Please share this video with everyone you know that are confused about this new immigration rule in the UK. So, this is what I am saying. Firstly, if the lead applicant has applied and granted an entry visa to the UK as a carer under the rules in force before the 11th of March 2024, sponsored in either or both these SOC 2010 occupation codes 6145 or 6146, a dependent may apply. To be eligible for this exemption, the lead applicant's original application date must have been before the 11th of March 2024 even if that application was granted after the 11th of March, and whether or not their dependents applied at the same time. This is to buttress the fact that as a carer who already applied for a UK visa even if was approved after March 11, 2024, you don't have to worry about the new rule. Your dependents are allowed to join you on your visa in the UK. Another general exemption to bear in mind is if the dependent is a child who was born in the UK, the child can apply even if it means that the other spouse, father or mother are not allowed. That's weird, I know. The next question is what about those who applied after the 11th of March 2024? To answer this question, let us consider the next 6 examples coming up next.
Example 1. Migrant A has been sponsored as a care worker with their partner and child since the 10th of January 2022. In this case, their dependents, both adults and children, can continue to apply as such. Example 2. Migrant B has been sponsored as a care worker since the 25th of November 2023, but had not applied for their partner or children. Also, in this case, they can make an application for their dependents to join them at any time during their period of leave. Example 3. Migrant C has been sponsored as a nursing auxiliary since the 10th of July 2023, but switches to being a senior care worker with an application made on the 15th of March 2024. In this case, because they switched their job code to that of a senior carer after March 11, 2024, their dependents will not be allowed to make applications in connection with their leave as a senior care worker. In essence, if they had continued on a visa other than senior carer or care assistant, their dependents would not have been affected. Example 4. Migrant D has been a student since the 1st of September 2021 then switches to being a care worker, having completed their course, with an application made on the 1st of April 2024. In this case also, because they have made their application after the 11th of March 2024, their dependents will not be allowed to make applications in connection with their leave as a care worker. Example 5. Migrant E has been sponsored as a care worker since the 1st of June 2023, but switches to being a senior care worker with an application made on the 25th of March 2024. In this case, the system would treat Migrant E as one of such already being sponsored on the affected visa, and their dependents will therefore be able to make an application under their visa. Lastly, example 6. Migrant F switches from being the dependent partner of a student to being a senior care worker with an application made on the 10th of March 2024. In this case, subject to course completion requirements, their partner can apply as their dependent because the application was made before March 11th.
In the midst of all these, the Home Office also put in place something known as recognition of previous leave. You have to carefully consider this. According to the government, where a migrant has been granted permission as a dependent and the lead migrant changes job or switches to another PBS route which allows dependents the original permission, which the dependent holds, will continue to be valid. Where dependents are already in the UK and the lead applicant switches to care worker, they will have chosen to do so in full knowledge of the dependent rules. This is therefore not a reason in itself to allow the dependents to switch exceptionally, unless of course they are children born in the UK who are allowed under the rules. If the new permission granted to a lead applicant does not allow dependents, it will not normally be appropriate to cancel those dependents' existing permission, unless there are other reasons to do so. A decision not to cancel does not mean there is any expectation of further permission. Once this existing permission ends, they cannot be granted permission to extend their stay as dependents, if the lead applicant does not have a form of permission which allows dependents. Regarding adult children and other relatives, the rule is still the same: children who are 18 years old or older on the date of application, who have not previously been granted permission as a dependent of the lead applicant, cannot be granted permission as a dependent child. Similarly, other relatives, for example parents or grandparents, cannot apply. There are other circumstances where dependents' application can be considered under a rule known as exceptional dependent applications, where there are exceptional, compelling, and compassionate circumstances raised on behalf of a dependent who cannot meet the requirements to be granted entry clearance, permission, or settlement as a partner or child of a lead applicant. The case officer is compelled to consider that application outside of the immigration rules. If you have a case like this, you will need to talk to an immigration lawyer. While we at Visa Pathfinders are not trained immigration advisor, we are able to connect you to our proficient partner immigration lawyer. Send us an email at visapathfinders@gmail.com for further details. I do hope that this video has explained to you in further details how to move to the UK with your dependents going forward, as well as how to continue to remain with your family here in the UK. Thank you for watching till the end. If you have any question, leave us a comment under this video and we will answer them. See you later. Bye.